Welcome back, everyone, for another deep dive. Today, we're tackling something that's kind of a big deal, even if most people don't think about it much. Intellectual property. Patents, trademarks, all that stuff.
It's true. Most of us don't think about it until we need to, but we interact with IP every single day. The phone in your pocket, the logo on your coffee cup, it's all intellectual property.
Exactly. And it can seem pretty mysterious. I mean, patents, trademarks, copyrights. Sounds pretty lawyerly to me.
Yeah, it can feel like you need a law degree just to understand the basics, but the core ideas are actually pretty simple. And once you get those, you start to see IP everywhere and how it shapes our world.
So, ready to decode it all? We've got some great material to dig into today. And trust me, whether you're an entrepreneur or an artist or just curious about this stuff, you're going to find this deep dive really interesting.
Totally agree. IP touches so many parts of our lives. Understanding it, even just the basics, can be a real game changer.
Absolutely. So let's start with the million-dollar question. What is intellectual property anyway? I found this definition in one of our sources, and I thought it was a pretty good one. Creations of the mind, inventions, literary and artistic works, symbols, names, and images used in commerce. What do you think?
Yeah, that nails it. It's basically recognizing that the things people create with their minds have value, just like physical property. Your ideas, your inventions, your creative works, they're all worth protecting.
So it's like owning a house or a car. But instead of owning a physical thing, you own an idea, a design, a creative work.
Exactly. IP rights give creators control over those intangible creations, just like owning a house gives you control over your property.
It's your creation, and you get to decide how it's used, how it's shared, even how other people can or can't make money from it.
Exactly, and that's where those different types of IP come in. Patents, trademarks, copyrights, trade secrets, they're all about protecting different aspects of intellectual creation.
So we're going to unpack all of that, right?
We are.
Perfect. Because honestly, those terms, patents, trademarks, copyrights, they can seem so jumbled together in my mind. Like, what's the difference again?
It's easy to get them mixed up, but don't worry, we'll break it all down. Maybe focusing on patents and trademarks for today would be a good place to start. They're two of the most common forms of IP, and they illustrate some really important concepts.
Sounds good to me. Let's start with patents then. Whenever I hear that word, I think, okay, someone invented something. But I'm not always sure how you get a patent or what it really even does.
Right, it can seem a little mysterious. So picture this. You've invented something amazing. Let's say it's a self-folding laundry machine. A dream come true, right?
Oh, tell me about it. Sign me up.
A patent could help you protect that invention. It's basically a legal document that gives you, the inventor, exclusive rights to decide who gets to make, use, or sell your invention.
So it's like putting a fence around your invention saying, this is mine, I came up with it, and nobody else can just swoop in and take it.
Exactly. That protection is super important for encouraging innovation. Inventing something new takes a lot of time, effort, often a whole lot of money. Patents help make sure inventors can benefit from all that work, that they can make money from their creativity.
Because let's face it, if someone could just steal your invention and profit from it, why would anyone bother with all the hard work of inventing in the first place, right?
Precisely. Patents help make sure that people are rewarded for their ingenuity. But it's not about stifling competition entirely. It's about finding a balance.
Between protecting inventors, right, and also making sure the innovation keeps happening, that other people can build on those ideas and come up with even better solutions in the future.
Exactly. The patent system is designed to encourage that kind of knowledge sharing. When you apply for a patent, you have to explain your invention in detail, how it works, what makes it special. All of that information becomes public.
So even though you're protecting your invention, you're also contributing to the overall pool of knowledge, helping to inspire future inventors.
Yes. Inventors get a limited period where they have exclusive rights, but then that knowledge is out there for everyone to learn from and build upon. It's a cycle of innovation.
That's really cool. It's not just about keeping secrets. It's about sharing in a way that benefits everyone in the long run. Our source material actually mentioned that if you look at the history of patents, you see this pattern over and over again. Patent activity tends to surge alongside major technological leaps.
It's true. For example, back in the late 1800s, you had the rise of railroads, the telegraph, electric power. all these huge technological shifts, and patent filings went through the roof.
Makes sense. Big changes in technology lead to a ton of new inventions, and those inventions lead to more patents.
Exactly. And that pattern continued into the 1900s with cars and airplanes, then again in the 80s with personal computers. And now we're seeing it with everything digital, smartphones, the internet. It's like you can track the history of innovation by looking at patent activity.
It's fascinating. But let's dive into the nitty-gritty a little bit. What does it actually take to get a patent? I mean, I'm assuming you can't just patent anything.
Oh, absolutely not. There are specific criteria your invention needs to meet. In the US, for instance, there are three main ones: novelty, utility, and non-obviousness.
Okay, let's break those down. Novelty. That one seems fairly straightforward. It has to be new, right? No one's done it before.
You got it. Your invention has to be truly novel. It can't be something that's already out there, already been invented or described publicly. This is where doing your research early on is crucial. Before you even think about applying for a patent, you need to make sure your invention is truly one of a kind.
Otherwise, you could go through that whole process only to find out someone else already beat you to it.
It happens. So yeah, novelty is key. But then there's utility. Your invention can't just be a cool gadget that doesn't really do anything. It has to serve a real purpose, right?
So like a new type of toothbrush that actually cleans your teeth better. That would be useful. A gadget that just makes funny noises, not so much.
Exactly. It needs to have a function, a use, a real-world application. It has to solve a problem or address a need.
Makes sense.
Yeah.
So new and useful, check and check. But then there's that third requirement. Non-obviousness. What does that even mean?
That one can be a little tricky to wrap your head around, and it often trips people up. Basically, non-obviousness means that your invention can't be a super simple, obvious improvement over something that already exists.
So you can't just take an existing product, make a tiny tweak, and call it a brand new invention.
Exactly. You have to show that your invention involves a real inventive step, something that wouldn't be obvious to other experts in your field. It has to push the boundaries.
It's got to have that wow factor like, why didn't anyone think of this before?
Exactly. And this is where things can get a little subjective, because what one person thinks is obvious might not be so obvious to someone else. There can be a lot of back and forth between inventors and the folks who review patent applications.
So let's say my invention checks all the boxes. It's new, it's useful, it's not some obvious tweak of something that already exists. Does that mean I'm home free? Like I get my patent and I'm good to go?
Well, getting the patent is a huge step, for
Yeah.
sure, but it's not like having a magical force field around your invention.
Because I was just thinking, what's to stop someone from just copying my invention anyway, even with a patent?
That's the thing about patents. They don't actually prevent infringement. What they do is give you the legal right to sue someone if they infringe.
Ah, so it's more like the patent doesn't stop someone from copying, it just gives you the ammo to go after them if they do.
Exactly. And sometimes just having that legal protection, that threat of a lawsuit, is enough to deter infringers.
Makes sense. Okay, so we've covered a lot of ground with patents. Ready to switch gears and talk about trademarks.
Sure, trademarks are fascinating. They're all about protecting your brand, your identity in the marketplace.
So we're talking logos, those iconic brand names, even those jingles you can't get out of your head.
Exactly. Think about the Apple logo, the Nike swoosh, even that Amazon arrow. Those are all trademarks, and they're incredibly valuable to those companies. They represent years of building brand recognition, trust, customer loyalty. You can't just let anyone come along and use them.
It's amazing how much power a simple symbol or a few words can have. Like you see that swoosh and instantly you think Nike, athletic wear, quality, all of that.
Exactly. That's the power of a strong brand and of protecting that brand with trademarks. Because trademarks prevent other companies from using those same marks or something that looks or sounds confusingly similar.
So if I started my own athletic wear company and called it, say, Nika, with a swoosh logo that was just a little bit different,
Yeah, Nike would probably have a thing or two to say about that.
because people might see it and think, oh, cool, new Nike stuff, not realizing it's a completely different company.
Exactly. Trademarks are all about preventing that kind of consumer confusion. They protect businesses and consumers by making sure that when we see a certain mark, we know exactly what we're getting.
So how does a business actually get a trademark? Is it like the patent process? You submit an application, cross your fingers?
There are definitely some similarities. First, you need to make sure that no one else is already using the same or a very similar trademark for the same types of goods or services you offer.
So you have to do your research, like make sure there's not already a Nika out there selling shoes.
Yep. And there are databases you can use for this. The USPTO, for example, has a great one called TESS, the Trademark Electronic Search System.
Oh, yeah, that rings a bell. Didn't we talk about that earlier for patents?
We did. It has both patents and trademarks. Really useful resource. So once you've done your homework and you're pretty sure your trademark is available, you can file an application with the USPTO.
And I'm guessing this is where it gets a little more complicated.
It can. The application process is pretty detailed. You have to be really specific about exactly what goods or services your trademark will represent. Like, are you selling shoes, clothing, sporting equipment? You have to define it all.
So if you have a trademark for, say, clothing, that doesn't necessarily protect you if someone uses the same trademark for, like, a software company.
That's right. Trademark protection is tied to specific categories of goods or services. That's why you often see companies file for trademarks in multiple categories. They want to make sure they've got all their bases covered.
Makes sense. So you file your application, you've meticulously listed everything out. Then what? Is it a waiting game, like with patents?
Pretty much. The USPTO reviews your application to make sure it meets all the legal requirements, and that review process can take a while.
How long are we talking?
It can vary, but sometimes up to a year or even longer.
Wow, so you need some serious patience if you're trying to register a trademark.
Definitely. But if everything looks good and the USPTO approves your application, you get your registration certificate.
Which is basically like the golden ticket to official trademark protection.
Exactly. And it means you get to use that little symbol next to your trademark.
Ah, the symbol of this trademark is officially registered. Don't even try to mess with it.
Pretty much. It shows everyone that you've gone through the process, you've earned the right to use that mark, and you're serious about protecting it.
And what happens if, even then, someone does try to infringe on your trademark? What can you do?
You have legal options to defend your trademark. You might send a cease and desist letter warning them to stop. Sometimes that's enough. Or you might try to negotiate a settlement. And if all else fails, you can take legal action.
So it sounds like with IP, whether we're talking about patents or trademarks, you really got to stay on top of things. No resting on your laurels.
You said it. It's not a set it and forget it kind of thing. You've got to be proactive about protecting what you've created.
Which is exactly why we want to do this deep dive. We're arming our listeners with the knowledge to navigate the world of IP. So as we wrap things up, what are the top takeaways for our listeners, especially those who are just dipping their toes into the IP waters?
I think the most important thing is to be proactive. Like we were just saying, don't wait until there's a problem to start thinking about IP protection. By then, it might be too late.
Because someone might have already beaten you to the punch with a patent or, I don't know, slapped your brilliant brand name on a line of rubber chickens.
Exactly. So if you've got an invention, do your research early. The same goes for trademarks. See what's already out there. Start thinking about protection sooner rather than later.
And remember, there are resources out there to help you, even if you're not ready to hire a lawyer just yet. Like we talked about, the USPTO website, that's a treasure trove of information on both patents and trademarks.
For sure. And don't underestimate the power of good old-fashioned documentation. Keep detailed records of your creative process, your inventions, your branding ideas, dates, sketches, notes. It all matters.
Like a paper trail, but for your intellectual property. So if you ever do need to prove when and how you created something, you've got the receipts.
Exactly. And look, if it all feels overwhelming or you just want some personalized advice, don't hesitate to reach out to an IP professional. They can give you guidance tailored to your specific situation.
It's always better to be safe than sorry, right? And this stuff can get complicated, so having an expert in your corner is never a bad idea.
Couldn't agree more.
Well, on that note, I think we've reached the end of our intellectual property deep dive.
It's been great exploring all of this with you.
And to our listeners, we hope you've gained some valuable insights into the world of patents and trademarks. Remember, knowledge is power. Now go out there and protect your amazing ideas.
Absolutely. The world needs those creative sparks.
And on that note, we'll catch you on our next deep dive.